the recording of today's session will be available later on the YouTube channel of the Academy of Law. And let me introduce you to our today's outstanding speakers. I'm very happy that they agreed to join us. These are Mr. Joseph Dyke and Ms. Catriona Nicol. They are senior associates of McNair International, providing legal expertise, advice, and advocacy for complex international disputes and arbitrations. I'm kindly asking everyone to turn off their microphones for the time being to prevent any background noise. So I'm giving floor to our today's speakers for them to introduce themselves and start our today's session. Thank you.
Dana, thank you very much indeed for that very kind introduction. And may I wish a very warm welcome to everyone who has joined us today. My name is Joseph Dyke. I am a senior associate at McNair International. I've worked here for the last 7 years or so. I originally trained as an English barrister before moving out to the Doha office of McNair. And I'm joined today by my colleague, Catriona Nicol, who has worked at McNair for 10 years, an English qualified solicitor, as well as being called to the Californian bar. Catriona and I have, forgive me, over that time, gained a lot of experience working to support our senior members on a wide variety of commercial litigation and international arbitration in the English courts, in the International Court of Justice, in international arbitrations in Singapore, in Africa, in Europe, and around the world. It's a real pleasure to have been asked to make a contribution today to the AIFC and to the English Speaking Club in particular. One of the features of being a British person who has lived abroad for a long time is that one is very frequently reminded of how many people speak English very, very well, and indeed how badly many British people speak foreign languages. All I can say is that when I'm Prime Minister, things will be very different. We'll overhaul the language teaching at British schools comprehensively. But hopefully you'll have today a good opportunity to be able to hear presentations in the English language. And I'm reliably informed this is important for people studying English, to hear different accents. You'll be able to hear that my accent is an English accent. I'm often told an upper class English accent, though I'm quick to deny that. But you'll also hear Catriona's Scottish accent as well. There is a perception that the Scottish people are more difficult to understand than the English people, but that's not necessarily the case. And Catriona and I know this firsthand, because on a different occasion, when we both had to present at a conference in Tehran a few years ago, the organizers of that conference had brought along someone to do the translation, but they were not a professional translator. They were another lawyer who had familiarity with English and Farsi. Catriona was interrupted repeatedly to tell her how nice a voice she had. I was not interrupted at all, and I received no compliments whatsoever. So let's see how today goes. In terms of the topic that we have, and I'll share my screen so you can see the PowerPoint. Our topic for today is civil law versus common law jurisdictions, the key concepts and the differences in dispute resolution. Let's start then. Before we do, actually, I should say we're going to divide this the same way that Catriona and I divide all our work, which is I'm going to do the nice easy bit at the start and talk about the key concepts and the historical origins. And Catriona is going to do the difficult bit of explaining what those differences mean when litigating. So let's dive in. civil law, common law, still the two principal legal systems of the world today. Key examples of the common law jurisdictions are England and Wales, for reasons I'll come to shortly, as well as the USA, Australia, and countries throughout parts of Africa and parts of Asia. Civil law jurisdictions, including Qatar, where we're both speaking from, much of Europe, and then an increasingly large number of what are known as hybrid jurisdictions, of which Scotland, of course, we have there as a proud member. Other legal systems or bodies of law also play a very important role in jurisdictions. Of course, Sharia law plays a huge role in an increasing number of countries across the world. And whether a jurisdiction follows a civil law or common law approach can have some quite significant practical differences for lawyers, particularly when they are dealing with the resolution of disputes. It is the case that many commercial transactions continue to be governed by English law or other forms of common law. And so common law is very often encountered by civil law practitioners, and of course civil law by common law practitioners too. What do the terms actually mean? What's civil about the civil law and what's common about the common law? Well, I'll start with the civil law because I like to go chronologically, and civil law is much, much older in origin than the common law. Where does the civil bit derive from? Well, it comes from the Latin phrase jus civile, law civil, if you like, which is those laws that were designated by the Roman authorities as the laws, or more accurately, the privileges, which were to be enjoyed only by citizens of the Roman Empire. Other people within the Roman Empire, but which were not citizens of it, known as Gentiles, were governed by a different body of law known as jus gentium. And jus civile, I'll just say civil law from now on, was strict, it was narrow, and it was limited in terms of providing for procedures and defining what those procedures were. In other words, very often it was excessive and wasn't adequate for ensuring justice in many cases. In time, an office known as a praetor, that's Praetor, a praetor, was established. The praetor would be someone from within a community who was respected, who was learned, who had studied what we would call law, principles, customs, who knew what to do. They would be called upon in a case where the Roman law seems to be giving out an excessive result, to see if they could give an opinion on whether the Roman law should be applied in its straightforward way, or alternatively, whether there were some characteristics of the case or some local customs or some reason why a more liberal approach ought to be taken in those circumstances. So whilst it's very often said, and indeed it says on the slide, that Roman law forms a very strong foundation for the development of civil law, civil law was always rooted in local customs, wherever it was found, wherever it was applied, because it wasn't being disseminated and applied by courts. Rather, it was being applied by praetors, subject to their own personal characteristics, predispositions, how they thought. No strong central court system existed throughout the Roman Empire, applying a single set of laws consistently. However, individual praetors would become well respected across fairly large areas, geographical areas, as jurists. And this set the tone for how civil law developed in the centuries to come, because it's often said that civil law is much more rooted in academia, in universities, than the common law is. But the big development came in the 6th century, when the Roman Emperor Justinian gathered together a collection of the leading jurists of that time, and he set them the task of compiling a code, one codification of all the laws that applied within the territory over which he ruled. That really monumental body of law came to be known as corpus juris civilis, corpus, body, civilis, civil, juris, law, sometimes known as Justinian's law. However, although this was the first great effort at codifying, and codification really is the cornerstone of civil law jurisdictions, unfortunately, it was lost within a few decades of it being created. So you can all take comfort the next time you misplace your keys or your mobile phone, that at least you didn't lose the book in which all the laws of Kazakhstan are written. But as everyone's grandmother says, if you look for something lost, you will eventually find it. And it was found a mere 500 years later in Italy by scholars who were at the University of Bologna, which had by that time become one of the leading academic centers in the development of civil law. So whilst the Roman Empire declined, its principles were being taken on and moderated by scholars, adapted by scholars to suit contemporary needs. But still no central court system disseminating consistent legal judgments, speaking with one voice on the principles. Local custom continued to influence the application of the law wherever civil law was found. So you might have civil law applied very differently in the countryside of Germany versus the city of Milan, to take one example. As I said, that process of trying to codify large bodies of law into huge codes intended to be comprehensive really is the fundamental characteristic of civil law jurisdictions. They're intended to provide both substantive law and procedural law for all conceivable situations. Not necessarily that all those situations are described, but the principles are that the judge or whoever is supposed to figure out how to apply those to any situation. And at different points in time, efforts were made in various European countries, primarily, to create these huge comprehensive codes. And some of the main examples are in Austria, 1786, the Code of Joseph II, and 1811, the Complete Civil Code. In Prussia, the Complete Territorial Code, 1794, and perhaps the most successful example, one of the most prominent examples, the French Civil Code, known as the Napoleonic Code, which was promulgated in 1804. Those codes form the model of most of the civil law systems that one encounters today. So what about the common law? What's common about it? Well, the common law is the law that emerged in England at the time when England moved from a period where there had been lots of different smaller pieces of land governed by lords, barons, whatever, into a centralized country ruled by the King of England, following the Norman conquests in 1066. So in other words, the common law is that body of law that came to be common to all the land ruled by the King of England. Similarly with the Roman law that I mentioned at the start, it was rigid, it was inadequate to achieve justice in lots of cases. The way that the English system tried to deal with that was by establishing something called the Court of the King's Chancellor. And so this is where the strong, centralized court system comes into play. One court at the center of the state, applying the law, judges speaking with one voice, more or less, to establish what the law is. However, that led to dissatisfaction because the King's Chancellor's Court, sometimes known as the Equity Court, was authorized to apply different principles to that of common law. In other words, it could borrow from other systems, like civil law, for example. And over time, the extent of influence that the king had on the creation of law was dissatisfactory. This came to a head, I won't go into the whole history, but this came to a head following a very devastating civil war in England in the 17th century, in which Parliament emerged victorious and established permanent checks on the powers of the king and claimed for itself, Parliament claimed for itself, the right to define what the common law is and elevated it above, gave it primacy above any other legal systems that still pertained in England, such as the law of the church, for example. The next big development in the common law is that by virtue of the British Empire expanding across the world, the common law went with it and was disseminated throughout the imperial possessions of the former British Empire. And thus it still provides the basis for many of the Commonwealth or former Commonwealth jurisdictions. The key examples being, some key examples being Kenya, Uganda, Tanzania, Pakistan and India, and of course the USA. That gives rise to an interesting temptation for English lawyers to assume when they travel to other jurisdictions for cases that they can carry their own law with them wherever they go. That's a temptation which needs to be avoided. In the last 3 or 4 years, I've been assisting the head of McNair International in a case in the Kenyan courts, where he was engaged to be the lead counsel for the prosecution against the person who used to be the Deputy Chief Justice of Kenya, who was charged with various criminal offences. Much of the law that was relevant to that did come from Kenya, but there were some principles that the Kenyan courts hadn't yet dealt with. And so we brought English authorities, English cases, to assist the judges. The judges did find them helpful and did refer to them in the judgment. But the lawyers on the other side, who were not terribly happy about English lawyers turning up to prosecute one of their judges, made very clear that they practice Kenyan law, not English law. And indeed, one of them shouted it at me across the courtroom. So to return to the slide, civil law comes from large bodies of codified written law intended to be comprehensive, establishing the substantive law for almost any conceivable situation. And the role of the courts is then to figure out how to apply those codes to the case in front of them. Common law developed in a completely different way. It developed from starting with the cases. Over time, maybe hundreds of cases, principles start to emerge from that. You can see what judges are doing consistently and over prolonged periods of time. After almost exhaustive examination, you get principles which are on page 1 of your textbooks. That's how common law develops. As I say, you go from, in the civil law context, you start from the code. What's the general principle? Then you look down into the facts of the case and see how the principle gets applied. Common law, you start with the facts. What principles does it give rise to? And then you work up back to the point of principle. I'm not going to go into this one in great detail because this is starting to move into what Catriona is going to talk about. But this is a really fundamental point of difference between the two systems. The concept that common lawyers call precedent, sometimes used with a Latin phrase called stare decisis. In other words, if a judge, particularly a judge that is higher than the one hearing a case, has already determined a particular case in a particular way, that judgment will be binding when a subsequent judge comes along to decide a case on the same or similar facts. The advantage of this in the common law context, of course, is it gives rise to certainty. Because if you're a litigant, or if you're a lawyer advising a litigant, you can look at the judgments and say, that's going to go this way, that's going to go that way. You can figure it out in advance. It's not subject to a particular judge trying to figure out how to apply a principle. In reality, as I say on this, which is my final slide, it's important not to overemphasize these differences. Even that one that I just explained, the concept of precedent, which doesn't exist in civil law, even that is being diluted, you might say, because in civil law countries, there is still a right of appeal. There's always a highest court that you can appeal to, and a judge knows that. So if a judge knows that if they make a decision, more senior judges are going to be looking at their decision, maybe, if a party decides to take an appeal, and they're going to be reluctant to put themselves in a position of being repeatedly reversed or overturned by a superior court, particularly if that has impacts on them, maybe in a system where judges are government appointees, for example. So it's not necessarily true to say that just because there is no doctrine of precedent in a civil law jurisdiction, that previous decisions mean nothing at all, or that the civil law itself is uncertain. In the same way, we also have very large bodies of statutes, particularly in England, where we have, for example, the Companies Act 2006 that runs to more than 1,000 sections. These are intended to be comprehensive legal codes for their specific subject matter. And you cannot avoid referring to those in disputes where they are relevant. Nevertheless, as Catriona is going to come on to shortly, it is clear that lawyers trained in one system always have to bear in mind these are two distinctive legal cultures. And when you travel to another jurisdiction and engage with lawyers from a different jurisdiction who've got a different concept, it is important to keep some of these fundamental differences in mind. that brings to a close my easy introduction, and I'll hand over to Catriona now. Thank you.
Thank you very much, Joseph. As Joseph has pointed out, and some of you may gather from my accent, I am originally from Scotland. And some people do find it slightly more difficult to understand. Scottish people have a very bad habit of talking very, very quickly. So if you find that I do start to talk too quickly, particularly when I'm nervous, because I don't think I've seen this many people on a Zoom call for quite some time now, please feel free to tell me to slow down. Joseph does himself a disservice. Actually, setting out the differences between common and civil law systems isn't as easy as he pretends it is, or as indeed he makes it look. However, as he's pointed out, it's also important not to overstate those differences. Whilst there are significant differences, and particularly as we'll talk about in litigation, you'll find that with the world becoming increasingly more international, those differences don't always mean as much as they might do at first glance. Joe, do you mind moving to the next slide, please? Before we go through the differences between civil law and common law systems in litigation, I thought it might be useful to just very quickly look at the path of a claim in the courts. For many of you who are in practice, this will be completely normal and you will understand this fully. So please feel free to switch off for the next couple of minutes. But I thought it might be a useful refresher for those who are perhaps in transactional practice rather than disputes, and also for those of you who are just studying. The starting point is that when you file a claim in the courts, that's not always necessarily the first point of a dispute. There's actually often steps before that. For example, in England and Wales, before you file a claim, in certain circumstances, you're required to do what we call pre-litigation steps or comply with pre-action protocols, which are a way of getting the parties to start talking to each other rather than running straight to court. In certain circumstances, you may also consider whether you want to file some kind of application or injunction before you go into court. For example, if you have a worry that as soon as you sue another party, they will start to take assets out of the jurisdiction, then you might decide that you want to put in some protective measures like a freezing order before they try and do that. Once we've done that, we then get to the filing of the claim. And this is where it may well start to diverge between a common and a civil law system. The path of the claim that I've set out here sets out broadly the system or the process that you would follow in a common law jurisdiction, where you would file your claim and you would wait for a defence to be filed. And after that, you would enter into a process of disclosure evidence before you got to the final hearing. Now, in a civil law system, as we'll go on and talk about, those steps may happen simultaneously and in less of a progression than you would see in a common law system. Next slide, please, Joe. It's always strange not having control of your own slides. Feels very, very odd to me at the moment. I'm going to take civil law first on the basis that that is the way in which Joe has generally dealt with it, so it's a bit more consistent. Now, in a civil law system, we find that when parties are submitting their cases or their arguments, they will do those almost in one batch. So the parties will submit their arguments along with the evidence in support of their position, whether that is documents, whether it is witness evidence, or whether it is perhaps expert reports. And often, precursor, what I will say is there are many different civil law systems in the world, and there are many different common law systems. And those systems, whilst they have things in common law systems will do things differently from other common law systems. So this is more a general guide rather than a hard and fast rule as to how every civil law system will do something or how every common law system will do something. But generally in civil law systems, the parties will submit their arguments along with their evidence, and they'll often do these simultaneously. They will then be put before the judge. The judge will review what they have in front, and then the judge might say, well, actually, I would like some more evidence on X. You've not given me any details as to this factual matter. And the parties will then submit another round of arguments, which set out the arguments, but potentially with additional evidence. And you will have multiple rounds of these memorials until the judge considers that it has enough information that they can determine the case. In contrast, a common law system will involve more of a progression. So the parties at the start will set out their statement of claim, their defence, where they say, this is what our case is. This is what we say. We have the evidence in support of this. This is our general position. And then they will move on to the next steps. So they will go through the process of disclosure, where the parties exchange documents that are supportive or against their case. They will then have the opportunity to review those. They will then file witness evidence, where they'll put together witness statements, and they will exchange those. Once the parties have all of the evidence in front of them and the judge has all of the evidence, then an oral hearing will be held, where lawyers from each party have the opportunity to cross-examine, to ask questions of the other side's witnesses and experts, to poke holes and to argue their case in front of the judge. Once that hearing is concluded, the judge will then decide the dispute based on the arguments and the evidence that have been put before them. Next slide, Joe. This actually follows quite nicely into the role of the judge. And even from the summary of how that procedure happens, you can see how the role of the judge differs. In a civil law system, the judge receives the arguments. He then asks questions as to what information he needs there to decide. So in a civil law system, the judge's role is more of an investigator. You receive their material, you work out what's missing, what else you need in order to solve this problem. The judge's role in a civil law system is to identify the facts of the case based on what the parties are bringing, and then to decide the case by applying the applicable statute to those facts. In a common law system, though, the judge's role is appropriate, given Qatar has the World Cup in a few months. Judge's role is more of a referee. So the parties will submit their arguments, their evidence, and the judge will almost ping pong between the two, looking at each side. And once it's reviewed all of the things that the party has, or the parties have put in front of them, then they will determine the dispute based on that material. We often say here that the civil law judge has the ability to ask questions and to call for more evidence, etc., whereas the common law judge is really to look at what is put in front of them. That's not to say that the common law judge can't ask questions themselves, because it might be that they feel that they need to ask a question in order to identify a particular issue or to say something. They can't necessarily say, wait a second, bring me the contract or bring me evidence, but they can say, well, you say that this contract was concluded here, but I don't understand how this has arisen. Maybe you could explain more. That might be a signal to the lawyers or to the parties that there's something missing in their case or some issue that hasn't really been dealt with. And that's what we say that's what we mean when we say, whilst the systems are different, the differences aren't necessarily as stark as you would think. Next step, Joe. You can see there from the role of the judge that the role of the lawyers will also be different as well. So we often say in common law that the lawyers take on a much more adversarial approach, a much more aggressive, a much more pushing their client forward. In a common law system, you'll see that the lawyers take on a much more active role in presenting the case and the evidence to the judge, rather than the judge calling for what evidence, what facts he needs. Lawyers will often decide what evidence, what information needs to be before the court in order for them to determine the case. The lawyer will produce evidence on behalf of their party, but they'll also ask for evidence from the other side, which we'll come on to in disclosure. They will cross-examine witnesses to pull out information that wasn't necessarily in their witness statement, and then they'll present arguments based on the evidence by both parties. The lawyer's role in that case is to persuade the judge that their party's view of the facts in the law is the correct one. In a civil law jurisdiction, because the judge takes such a forward step in terms of requesting what evidence, what information they need, the lawyer's role is more to advise the client on the law, prepare the legal filings, and provide and answer the questions that the judge has asked. They will look at the information before the court, the information the judge has asked for, and use that to build their client's case as to what is the correct answer. Next slide, Joe. Disclosure is simultaneously, I would say, probably the biggest difference between a civil and common law system, and also often the biggest headache to Joe and I when we are in litigation. Civil law, relatively straightforward. There's no, and note my little asterisk there, there's no obligation to disclose documents. The judge will decide what documents and what evidence they need. My little asterisk there is because in some civil law jurisdictions, there is an ability to request disclosure, but that is generally quite limited. The parties will say, we want this specific document, and they will do that in an application to the judge, who will then request that document. In contrast, in a common law country, there is a huge obligation to disclose. And as part of the litigation process, parties are required to search for all relevant documents, whether those are hard copy, electronic, your emails, your WhatsApp records, and disclose documents, both those that are in favour of your case, but also those documents that are against your case, unless they're protected in some form. And one potential form is legal privilege. So where you have correspondence between a client and their lawyer, then those will generally be protected by privilege. The disclosure process can be complicated, it can be difficult. You'll have circumstances where each party will put together a list of the documents that they're requesting. And there will be some discussion over whether those are to be produced. And often the judge will have to rule on what is potentially relevant or not relevant to the case. This means that disclosure it can be a huge, even in the smallest of cases, it can be a huge task. It can be difficult, it's expensive, depending on how many documents you have, where those documents are located, what language those documents are in. You might actually look for third-party assistance to review those documents. It's also quite intensive on the lawyers because it requires a lawyer to review all of their own party's documents, but generally also all of the other party's documents. And because of that, it means that there's a major impact on the time involved, the work involved, and the cost of the exercise as well, in a way that you don't necessarily get in a civil law case. Can you move on, Joe? Thanks. Turning to witnesses, the main evidence that you'll often find in cases falls into either documentary evidence, which is where the emphasis often is in civil law jurisdictions, and also witness evidence. When we talk about witness evidence, we're also including expert reports in that as well. They're not always necessary in a case, but where cases are more technical or more involved, then you might well decide that you need an expert. In civil law, there's less emphasis on oral evidence, and this is partly because there is a more limited ability or scope to cross-examine or test the evidence of a witness in the same way. That ability does exist to some extent, but not quite in the same manner as you would probably see in, for example, Suits, Ali McBeal, showing my age here. Instead, in civil law jurisdictions, the importance is more on documents and independent experts, which can potentially be appointed by the court. In contrast, in common law, there's more emphasis than in civil law jurisdiction on witness evidence. So recognition that not everything is always documented, whether in a contract or whether in an email. So witness evidence will often feature in these cases. However, and this is what I referred to at the start, even between common law jurisdictions, the way in which witnesses are handled will differ. In England and Wales, a lawyer will work with a witness to prepare a witness statement, which will cover only facts. It doesn't cover argument or law. And that witness statement will be put into evidence. It will be sent to the other side, will be before the court. And the witness can then be cross-examined at trial by the lawyer from the other side. Well, we're drafting witness statements. In fact, we've just finished 2 last week, so this has come at a good time. We often say to our witnesses that they have to be absolutely comfortable and clear and happy that anything that goes into their witness statement that they can deal with, that they can handle in cross-examination. In the same way, it's important that when you're putting together a witness statement, that it's in the witness's own words. You don't want to write something that is too lawyerly or that is too technical, only for a lawyer on the other side to ask them a question, the witness to look at you because they don't understand how something's been written, because it's not the words or the language they would normally use. And for them to tie themselves in knots that way. In contrast, in the United States, they follow a process more of deposition, where a witness will, or deponent as they call them, will sit in a room with the lawyer from the other side who will ask them questions. Their lawyer can object, but they will go through, and the purpose of depositions are more to gather information, either against for your case or in favour of your case, and pull out facts. In contrast to the witness statements, those depositions won't always go before the court. They can be put before the court in limited circumstances. The main ones being where a witness is unavailable, either they've died or they've fled the country to avoid being present, or alternatively to impeach a witness. So where you have a witness on the stand who says something which contradicts something that they told you in their deposition, then you can put the deposition there to say, well, hang on a second, let's talk about this. Next slide, please, Joe. So once the judge in the case, and I'll deal with this very quickly, because I'm conscious that Joe has talked about this as well. Once a judge in a case has the information before him or her, whether that is as a result of multiple rounds of pleading, as in a civil law system, or whether that's because you've come to the end of your process of pleadings, disclosure, witnesses, and trial. The judges will then look at deciding the case. Now, in civil law, as we've talked about, the judges will identify the relevant facts and they will determine the case by applying the applicable law or civil code to those facts to come up with a decision. In common law, the judges will determine the case by looking firstly at the law, but then by focusing on precedent, on previous judgments in similar areas. There's some argument amongst predominantly common lawyers, I would say, that this leads to more consistency because it means that cases with the same or similar facts will be determined in the same way. Civil lawyers may well disagree with that. I think the view of common lawyers is that you could have 5 different civil lawyers looking at the same statute and the same facts, but they might have a slightly different interpretation. Whereas with common lawyers, there's more of an emphasis. Whether that's the case or not is possibly something for the discussion at the end of this. You'll also see quite a stark difference when you look at judgments. So when you look at a judgment of a judge in a common law jurisdiction, you'll see that they will set out the initial facts, then they will turn to the law, and then they will move into cases that have dealt with similar topics, similar fact patterns. Whereas a civil law judgment will focus predominantly on the law. Having said that, there will still be references to previous decisions and previous cases, which is where we again come back to that whilst there are differences between the systems, those differences aren't necessarily as pronounced and as significant as you may otherwise think. Last slide, Joe. So finally, last slide, costs, probably the one that is after the judgment of most interest to clients. Civil law, generally, not a hard and fast rule, generally lower costs, and they tend to be a bit more predictable. And that's because in the common law system, you have the issue of disclosure and complexity of cases. And disclosure is one of the main reasons for driving up costs. When you look at the factors we've talked about already in terms of the amount of documents, the pressure on finding those documents, the pressure on reviewing those documents, and the time that that takes, and the obvious cost that that takes, that means that you can end up with a significantly higher cost. However, in common law, the winning party has the relief of knowing that often their costs will be recoverable. Typically in common law jurisdictions, there will be a provision that says that the successful party can recover their costs. Not entirely, it's within reason, but they do have that. In contrast, civil law jurisdictions, there is less ability of a winning party to recover their costs. Typically, the costs will fall on the party that has incurred them. I think that deals with, and I'm conscious that this has been a whistle-stop tour, but I think this deals with sort of the main highlights that I wanted to cover in this section of the presentation. We could spend hours talking about this, but I'm also aware that it's nearly 6 p.m. and that many of you have families, pets, and dinner that you would probably like to get back for. So I'll finish on a few high-level points. The differences between the two types of legal systems exist, but they're less stark than they were historically. And we've covered some examples of how that is the case. But they do still exist, and their impact should not be underestimated. The two types of system frequently interact with each other. You'll find so many commercial transactions nowadays involve parties from at least 2 jurisdictions. And there's a high possibility that at least one of those jurisdictions will be common law and the other will be civil law. It's important as lawyers to be aware of the differences between your own and other systems, not just if you're a dispute lawyer and you might find yourself in court or advising on a case which will be in court, but also as a transactional lawyer when you're drafting dispute resolution clauses, working out where any disputes might be dealt with and the impact that that might have on your client in the event that some kind of dispute arises. Joe, before we turn over to discussion and questions, I don't know if you had any other points that you wanted to raise.
I don't think I do off the back of that, but we definitely thank everyone for listening. And Denaya, I think we're in your hands really as to where we go from here in terms of questions and answers.
Okay, first of all, thank you so much for your interesting presentation. That was very useful for a brief presentation, actually, to understand the main difference between the two jurisdictions. And immodestly, I will take my first turn to ask a question. As you may know, and as most of us must be aware, the AIFC law is based on the principles of England and Wales, which is common law jurisdiction. You've told us about the difference in procedure, saying that in common law systems, the procedure takes less time, less physical presence of 2 parties and the judge, but the costs are higher. How can we use this information to elaborate on why in the international commercial community, common law principles are more attractive and gain more trust?
Joe, I will jump in on that one, unless you want to take it. I wouldn't say that cases in common law systems require less time or less involvement of the parties, the lawyers or judges. To some extent, there may be less interaction from a judge compared to the questions that you might receive from a civil judge, but certainly time-wise, I think the investment by the parties and their lawyers is just as high as you would receive anywhere else. In terms of the attractiveness, very much speaking as a common lawyer here, and I think it's only natural that many lawyers have an affinity for the system in which they are raised in. I think it helps having the interaction between the parties and being able to follow that process rather than feeling like you're pushing different information, different arguments forward the whole time. But I would also say that in terms of judgments, I do think there is probably something to be said for the consistency of judgments. Certainly from a party's perspective, I think that for a client, it's much easier for a client to look at or to have previous judgments explained to them, to say, if this is the way that the dispute goes, then it is likely that a court will find X, Y, and Z. Whereas you could have two clients looking at the same piece of legislation who would both take a completely different interpretation of that legislation and might not be able to look at judgments to work out where they would fall in the event of a dispute between themselves. Cost is obviously a major issue in common law jurisdictions, but there is a recognition, particularly in relation to disclosure, that that needs to be reined in and that needs to be dealt with. And it's outside the scope of probably this discussion, but there have been attempts in England and Wales, certainly, to try and take steps to reduce that disclosure burden on parties to prevent it getting out of hand, both in terms of time and cost. I can see that we have two people with their hands up.
Thank you
So
for your answer.
I will not labour that point anymore. Sophia, I think your hand was up first.
Yep.
Is this a question?
Yes, thank you so much. Firstly, I would love also to thank you for such wonderful presentation. It was extremely useful to summarize everything about main differences, main aspects of jurisdictions. I would love to find out more about your attitude towards main issues of recognition and enforcement of judges or of judgments, for example, of civil law jurisdiction in common law jurisdiction. So how does this process nowadays takes place, and what are the main maybe issues and difficulties of this process of recognition and enforcement on international level? Thank you.
Joe, do you want me to jump in and then you can add anything?
Please.
Sophia, so broadly, and I will deal with this in the England Wales system, under common law, there's foreign judgments aren't necessarily recognised immediately. You would have to make an application and attach the foreign judgment in order to provide evidence, and they would take steps. There tends not to be any real drive into that judgment. So there shouldn't be that much of a conflict between the common law and civil law systems. And because an application has to be issued, it's not as if you're importing a civil law judgment directly into a common law system. George, is there anything that you want to add on that?
Yeah, just again, staying within the English framework for now, much of the recognition and enforcement of foreign judgments is done under two different statutes, which each of which govern different groups of countries and were enacted at different times. But even though those statutes both provide for, or are intended to provide for, very straightforward or streamlined processes for recognition. So as Catriona says, there's no real drive to look behind the merits of an award, except in defined exceptions, usually to do with public policy or if a judgment's been obtained by fraud. Outside of those two statutes, so if you're talking about bringing a judgment from a country that isn't within either of those two groups, then it falls to common law principles, most of which are the same as the statute anyway. So in most cases, there's not too much difficulty from the English court's perspective in terms of dealing with and understanding judgments from foreign jurisdictions, and many English judges are familiar with that. Catriona and I also deal with quite a lot of arbitration, which provides for an even more generally streamlined process under the New York Convention for very straightforward recognition and enforcement of foreign awards. So overall, the intention is make it streamlined, make it straightforward, no real looking into the merits of the case.
I think now we'll take Kushnazar and then Claudia, if we could take you after, if that would be okay.
Yep. Kushnazar, we cannot hear you.
still can't hear you, I'm afraid, Krishna.
Okay, I can. I think we may move to Ms.
Shall we?
Claudia. I would want to note that Ms. Claudia is a member of Legal Services Board at the AIFC.
I recognize your name, Claudia, from the Legal Services Board, which does fill me with slight trepidation at your question or comment.
It's first of all, I'm really impressed about the presentation and to summarize the two legal systems. Just two remarks, less questions and two remarks because also with regard to commercial transactions and we have this continuously between the French and the German litigation. I think the German litigation that's one of the very few where you fully get recovered your costs if you are winning the case. So, and this is where our French clients are always relieved, because in France, not that way. So there you really get covered your costs, but the impediments are more in the duration of the litigation at the court. And I would also like to add that when we go into a litigation and commercial transaction, very much we don't have the case law, but we know very well that different local courts, in particular in commercial cities like Hamburg or Munich, we already know we prefer, dependent on whom we are defending, we know how they will decide more or less in favor of the companies, or if they are like Berlin, rather in favor of employees. So we are monitoring a bit also because we know the tendency of how they are deciding in commercial transactions. So, and that's why in conclusion, I can completely underline what you said, that in practice today, they are getting more and more similar, there are differences, but there are many things that are at the end, we have the same thinking, how to approach it.
Claudia, that's actually really helpful, because it was a point that Joseph and I had discussed, and we're quite glad that you have mentioned this. In terms of a jurisdiction where you know that you have judges who may be open to interpreting civil codes or laws in different ways, does that mean then that you, if you're bringing a case, that you would tend to look at a different local court, or you would aim for a different judge to the extent that it was possible for considering a case, or what sort of steps would you take?
Yes, definitely. If this is possible according to the procedure, because it's quite regulated which court is competent. But for example, also if I go to a Hamburg court, it's knowing I would rather prefer to ask to assist a Hamburg colleague, because this is Hamburg is a very specific city. So if you come there as a Berlin lawyer, already there's already something you're missing probably. So, and yes, we constantly checking out which court could be the best for the case.
That is, I'm going to remember that one for future. and possibly also call you the next time that we have something over in Germany.
And Berlin is definitely not the best place. So if you can go to Frankfurt, Hamburg, or Munich, or Duisburg.
That's a shame, because Berlin is a beautiful city.
It's beautiful if you are defending an artist, or but never an owner of a building. And
okay.
But if you're a startup, whatever, so musical club, whatever, then go to Berlin. But
as
not
you can tell, I have my pen and I am taking notes on this.
but not for real estate.
Excellent, thank you so much. And Denaya, I think Krishna's
Sorry,
oh, sorry, Joe.
Well, I was just going to ask a follow-up, Claudia, if I may, what you say about being able to track particular judges' predispositions or whatever. Are there then tools that help you to do that, or is it down to sort of law firm knowledge? Because certainly in arbitration now, there is a lot of marketing done by people who claim to have studied everything and really gathered empirical data on every arbitrator in the world to be able to predict how they're going to determine a case. Is that something that exists in your jurisdiction?
Yeah, so also when it comes to arbitration, and of course I understand we see that the commercial arbitration courts, they need their cases and clients, but I have to say that meanwhile all the public courts, they have to offer a kind of mediation whatsoever before really getting into the litigation. And meanwhile, these are judges that are quite well trained. So I have, and this doesn't cost additionally. So the cost factor is crucial in this. And I have very good experiences in these mediations at the public court. So, but all these things we are checking out how to place the case. Yes.
Okay, thank you. So Khushnagar has still some technical issues, so I will read out loud his question.
Denaya, before you do that, actually, Joe, do you want to switch the PowerPoint off? Because actually, I'm looking at Khushnagar's question now, and this might be an interesting one for discussion.
Yep, sure.
Because I'm sure that actually people who are on the call may also have a view on this, and it would be interesting to hear other views rather than everybody having to listen to our voices any longer. Denaya, sorry for interrupting there. Do you want to read out Khushnagar's question?
Yep. So first of all, I'm starting to quote actually. First of all, thank you both for the presentation. It was informative. I have two questions and they are strongly linked with each other. As far as I know, civil law and common law have already started to integrate. Even cases were started to be used in civil law countries. My question is, do you think that there is any possibility of becoming those systems in a single system? I will proceed with the second one later, I think, or should I read it now?
Let's deal with the first one first.
Okay.
Khushnagar, you're absolutely right in terms of civil law and common law starting to integrate, in the sense that the differences are far less pronounced. As Joseph also mentioned at the start of his presentation, you do actually have some jurisdictions which are hybrid systems. And Scotland is, in fact, one of those, where it was originally based on civil law, but in time, the common law has developed more there. And I would say is probably more influential now, partly influenced by the fact that Scotland is still, and for as long as I have my way, part of the United Kingdom. And as a result, the highest court in the land for Scotland is the Supreme Court, which is only English trained judges. So whilst they may be determining matters of Scottish law, they do it with an English common law. And in terms of, do I think that these systems become one system? My initial answer is I think it's unlikely. I think that lawyers and legislators in both countries will have their own preferences and their own views on some countries which I think prefer having a codified civil system. There are other countries where there's such a strong common law tradition that I think they would be reluctant to drop it. What I do think is that as the world grows even more international, that there will be more crossover between those systems. And as you say, that you will see more and more cases being referred to in civil law jurisdictions. Simultaneously, you will also see more codification of law in other jurisdictions. For example, in England and Wales, I was in a previous life a tax lawyer. I focused on international tax structuring and corporate tax before I saw the light and went into disputes instead. And the tax code in England and Wales is gigantic. When I was there, it was over 10,000 pages, and that was 14 years ago. I dread to think the size that it is now. But the tax code is incredibly prescriptive to an extent that you don't necessarily need to look at too many precedents because it is so set out that judges can generally come to a conclusion without needing to rehearse 40 pages worth of precedents. So I think my long-winded answer to your very concise question is, I think it's unlikely that they'll become a single system, but I think that I think the differences between them will become less pronounced as time goes on in the way that they already have started to. Joe?
Yeah, 100% agree with that. And I would be prepared to bet that as time goes on, the phrase common law might simply be abandoned at some point, because it will be increasingly less justified as time goes on. My story about being shouted at for bringing in English decisions into the Kenyan courts pales into insignificance compared to a different story where we were asked to write an opinion on the constitutionality of some provisions of the Malaysian penal code relating to defamation, because defamation still carried criminal liability in Malaysia. And I found what I thought was the leading judgment from the Malaysian courts. It was a common law judgment in every sense, because the judge actually went on to become the king of Malaysia under Malaysia's slightly unusual system where the royal family sort of rotates around the different federated states. And there was plenty of reference to English law. I thought, brilliant. I'm not going to have to do much work here. Then there was a nice comparative section with India and Pakistan and other common law countries before concluding the time has come to depart from English law and to follow Indian law. So eventually the number of so-called common law countries continuing to follow English common law will one by one, I'm sure, slowly slip away. And so we'll see more, as Catriona says, more hybrid jurisdictions and probably fewer jurisdictions that would even claim to be common law.
Okay, thank you. I've seen some thumbs up from Khushnazar, so I guess this is, thank you. So the second question is, which law system do you consider the most effective? We have looked at all the pros and cons sides. I mean, what is the conclusion? Let's imagine there was a new country created. Which law system should be chosen for this new country? Thank you so much for your answers.
Yeah, Khushnazar is going to be a very good judge at one point. You've given me the pros and cons. What's the conclusion? I think again, we come at it with our own prejudices and our own trainings and our own slants, and naturally, of course, it goes without saying that we would suggest that the common law, with the advantages it brings on a serious note for commercial parties, increased certainty, readily understood, for unfortunate reasons, historical reasons, but it is nevertheless the case, readily understood by a lot of countries around the world, enabling trade, enabling treaties to be entered into very easily, enabling contracts to be entered into very easily. Common law, in my respectful view, probably should be adopted by this new country. I don't know where it is. That might have an impact too, but that's my answer.
Turning it round on you, and I'm very disappointed that I can only see about 3 faces, 4, including Claudia as well, and everybody else is hiding behind a black screen because it makes me feel very unequal here. But let's do a show of raising hands if possible.
Okay,
So
Aidana is the next person. Would like
sorry.
to...
Go on, Aidana.
Yeah, sorry, my question is very simple, but I would like to thank you both for such a wonderful presentation. I think, you explained the very complex legal system in a simple way, so thank you for that. My question is about the attorney-client privilege. So could you explain us what it is and why is it important, and what are the rights of the client and the attorney in this? Thank you.
Joe, I'll let you take this one.
Sure. So in essence, what it's about is it's an important feature, first and foremost, of ensuring access to justice, because there is no point in access to justice if everything that you say to your lawyer is going to be disclosed to the other side under compulsion. So it's about enabling people to be able to engage lawyers safe and secure in the knowledge that their discussions remain confidential, and that in ordinary circumstances, the court won't see it and the other side won't see it. In England, it gets divided into a couple of different branches or types of privilege. The first one is called legal advice privilege, which is more or less the concept I just explained. Communications concerning legal advice from lawyer to client, subject to privilege, can't be sought for disclosure by the other side. And then a slightly separate concept of litigation privilege, which is about documents that have been sent between client and lawyer for the purpose of litigation. So slightly separate and slightly more complicated. And there have been several court decisions on it recently in England. But the essential rationale of both of them is the same. It's about protecting litigants, enabling people to ensure that they can engage lawyers without fear of what they say being sent out to the other side or the court.
Yeah, thank you so much.
Okay, the next question from Mr. Bibut Murzinov, my colleague.
Yeah, thank you, Dana. Thank you for Catriona and Joseph once again. Just to dive into this question, it's very actually interesting for us to understand whether you are subject to this litigation or legal advice privilege if you are not qualified lawyer. For instance, you're just ordinary in-house lawyer and you're actually, I don't know how to say, the head of the department or somebody asked for legal advice in terms of corporate contract, etc. before the court proceeding or whatever. Are you subject to this privilege, or should you keep your communication with your head and everything actually, or you could disclose or discuss with the third parties?
That's a great question. It's something of a vexed one from the English perspective, and as the Eurasian Natural Resources Corporation has had to grapple with in its various litigation in the English courts. My understanding is there is another judgment expected on the subject soon. But yes, in that sense, litigation privilege is slowly being or attempts are being made to slightly broaden it out. So judgments on whether, for example, experts who are not necessarily lawyers, but are part of a kind of broader team that is put together for a dispute. There have been several important judgments to suggest that possibly in certain circumstances their communications might be privileged. One thing that the courts are always are always alerts to is whether a sophisticated commercial party that knows a bit about English litigation is trying to use privilege where it ought not to. So, for instance, slapping the privilege label on all the documents is ineffective. Courts always look beyond that. The general best practice is to be extremely careful as to who says what and who they say it to. Sorry, forgive me, my voice. But yeah, this is an area of law that continues to develop in England. Catriona, I don't know if you want to add.
So basically, you always need to be careful. So what is exactly the case, whether there is actual perspective that it will be kind of future dispute, and you always should keep this in mind and also inform your head as well.
So yeah, there are circumstances in which in-house communications can be privileged. An interesting case relatively recently involved the state of Qatar. which was suing the London branch of a Luxembourg bank, alleging a conspiracy to manipulate the Qatari rial arising out of the blockade in 2017. And what they were trying to do there, the bank that is, was protect or assert privilege over a report done by PwC into the facts of the matter. But it wasn't successful for two key reasons. Basically, it was just a fact-finding document, so it wasn't done for the dominant purpose of the litigation, which is the key test. But it also hadn't been produced in reasonable contemplation of a claim. It came way too early before there could have been any prospect of a claim. So the courts are always going to look into the precise circumstances, and everything's going to be dependent on those facts.
Great, thank you very much. Now it's a bit more clear for us, because in civil law countries, using this kind of privileges is something new actually, and just recently was introduced, and we are trying to introduce the best practice. And I heard that about this case you also mentioned about the ERG. So it's when actually company from a civil law country actually had a dispute in London, and when actually the English court actually extended this privilege of client attorney privilege to the lawyers who are not actually qualified in England and Wales, but the judgment was actually applicable in terms of this case actually. Yeah, thank you very much.
The only thing I would add in terms of a practical guide for in-house lawyers is, and I think it's a very difficult concept to come to from civil law jurisdictions sometimes, because you don't have that overarching obligation of disclosure, you've got less. Whereas there's much more fear in common law countries. If you have to provide everything, what is included in everything? In-house lawyers are slightly different complication, and you're absolutely right in terms of providing a practical toolkit. Because the in-house lawyer, in contrast to, for example, Joseph and I, doesn't have just one role to provide legal advice, but they're often wearing multiple hats. They don't necessarily have that arm's length relationship between client and lawyer because they're an employee of the business. And whilst their primary role will be to provide legal advice internally, they might also be asked, depending on the nature of the company, to provide business advice or to provide advice which has both a legal and business context to it. So the main thing we would say is that where you have an in-house lawyer in that situation, it's important to put in place some kind of procedures to make it clear what hat an in-house lawyer is wearing at any given time, particularly where that relates to either contemplated litigation or litigation that's already in process, and making sure that documents are marked privileged and confidential where that's appropriate, but not overdoing it in the way that Joseph then suggests can lead to the privilege label being wiped off everything because of concerns of abuse. But that was all I wanted to add on that. I'm not sure we have any more questions.
Yeah, thank you very much once again. Yeah.
No, thank you so much.
Okay. If there are no questions in the chat box too, only
I think Mina might have her hand up, although we can't hear your question, Mina.
Do you hear me now?
Yep.
Yes, we do. Thank you.
Perfect. So first, I want to make a comment, like from my own perspective, the civil law and common law, as you already mentioned, like previously there were more distinction between the system, but recently they kind of become more interconnected within the practice of countries. So we cannot combine them in one single system, and we cannot distinguish them like 100% separate them from each other because they are kind of interconnected. And I wanted to ask that, since there are some, of course, differences or different procedures while one case from the beginning that they start filing the case, and after the end that the judges, they make their decisions, in which legal system, like civil law or common law, the probability of making mistakes or making a wrong decision or pleading some innocent people guilty is higher, like in which of them, in your opinion?
Oh, now you're asking a political question in terms of, I'm not sure, Denai, if I want to answer on a recorded conference which judges in which legal system make the most mistakes.
I can actually stop the recording now if
No, it's okay. I'm only joking.
if this wasn't a joke.
No, you're fine. I think the difficulty when it comes to law is that we are often operating not in black and white where you have necessarily a right or wrong answer, but we're often operating in shades of grey where there are just more right and more wrong answers, but there are scales of them. And I know that sounds like a real cop-out of an answer, but it's not intended to be. I think potentially common law leads to a system in which you perhaps have more consistent decisions because judges are relying on decisions that have come before them. Whereas in civil law, you potentially have, if every single one of us on this call looked at one set of facts and one law, then there's potentially more scope for difference in the conclusions that we would come to, unless it was a very black and white, very open and shut case. I think in common law, there is an advantage for judges of being able to look at things that have happened previously to come to a more accepted answer. Now, whether that accepted answer is right or not is a different question. And you'll often see in England and Wales that judges or that cases will go all the way through the court system only to get to the Supreme Court and for the Supreme Court to turn around and say, no, you've got it wrong, or that's not what the law actually is. So I think the short answer to that is I think wrong decisions can be made in both systems. But I think that in circumstances where we're always dealing in shades of grey, I don't know if you can necessarily say that one system leads to more wrong answers than right answers. I think if one system did, then we would probably have got rid of it by now because people wouldn't have wanted to live under a system that was consistently given the wrong answer. And maybe that's your answer. Okay, Joe's laughing at me here.
I think next question from Aldina.
Hello.
Hi.
Can you hear me?
Well, yes, we can hear you. Can I see
great.
You?
Yes, I will try to connect my video.
That's okay. No, you don't have to. I've got faces on two different screens and I'm trying to draw between them.
Yes, I'm facing a problem with connection, so
don't worry. Voice is perfect.
Yes. First of all, I would like to express my appreciation for the speakers for very informative presentation. Yes, there is a lot to digest and we have very interesting topic discussions on the difference between civil law and common law. So my question will be most related to the Kazakhstan's perspective. And you will certainly well aware that in Kazakhstan, like our practice is basically based on the civil law. The commercial contracts is conducted. Our jurisdiction is in the civil law. So the business contracts is conducted and legislations as well is based on the civil law. While we know that Astana Financial Center, the court system is based on the common law. So what the impact you would foresee for the Kazakhstani investors in terms of these differences? And the second one, I believe it's always could be a challenging for the dispute settlement lawyers of the Astana Financial Center with regard to those differences. So if you could kindly reply for those questions. Thank you.
I can take a first go at that, perhaps. In terms of the model, if you like, of a common law jurisdiction, common law court within a broader civil-based system, certainly isn't unique so far. It's been tried and tested effectively, including in Dubai, of course, and in Qatar, where we are. Where the courts have become quite adept usually because the constitution of the bench is done in a particular way to ensure that it's not just blanket common law judges opining on a legal system that they're unfamiliar with. There will always be some sort of domestic expertise. That's certainly the case that the experience that we've had in Qatar. So that helps to ensure that fewer mistakes, if you like, are made there. And in terms of the experience of the investors, my understanding is that Astana is doing a very good job of providing comfort to those investors by ensuring that the common law approach, if that's what they are more familiar with, is there. In terms of challenges for that, it may just be a case of ensuring that you have lawyers familiar with both substantive civil law, procedural common law, and that does exist. It's not like there are two completely divergent branches of lawyers with no overlap at all.
I would echo that. The other thing I would say, and as Joe points out, this is something that we have experience of in terms of Qatar and Dubai, in having a common law financial centre that sits almost within a civil law system, is the importance of jurisdiction of the financial centre compared to the state. There's a natural tension between the financial centre and the state courts in terms of jurisdiction, and where parties might seek to bring a case within the financial centre courts, which more appropriately should go to the state courts, or where a state party that's contracted with a financial centre party would prefer that their dispute goes to the state courts because it's the system that they are more familiar with, or for other reasons. Typically in Qatar, the financial centre courts have been relatively strong in making clear where they have jurisdiction over a dispute, but also where they don't have jurisdiction over a dispute. And they've been conscious not to overstretch and provoke any political ramifications. In Dubai, a slightly different system has been adopted. I should back up and say the Qatar court and tribunal have had probably 250 cases since they started in 2009, 2010. In contrast, Dubai have significantly more cases than that. And as part of the tensions between the financial centre and the state courts, they've actually set up essentially a jurisdiction tribunal, which has some oversight into where there's a dispute over jurisdiction, where those cases should actually fall. I don't think that that's something that the AIFC needs. Your case law is increasing, but I don't see that there's been the same level of jurisdictional concern that would prompt anything like that. And I think as long as there's a certain jurisdiction clause and investors can be clear on where the disputes will find themselves in the event that they arise, then they will be relatively comfortable with that.
Okay, thank you. So if there are no questions, I've seen in the chat box many people saying thank you to both of our speakers and those actually taking part in the discussion. It was quite a time. In 1.5 hours, we actually established a slightly more understanding of what is the difference and what I've actually discovered that civil law and common law system are more alike than it seemed before. So thank you, Mr. Dyke and Ms. Nicol, for sharing your time with us and sharing your knowledge and experience. Also, I would like to extend our gratitude to Ms. Claudia as a professional legal practitioner, also sharing her experience in Germany practice. As I've mentioned before, the recording of our today's session will be available later on our YouTube channel. See you next time, and I hope to greet Mr. Dyke and Ms. Nicol in Kazakhstan, in AIFC in particular. Thank you so much. See you next time.
On behalf of both of us, it's been an absolute pleasure. We are grateful to you all for both having us and for being such a nice audience. Jo and I will arrange for the slides that we've used to be sent over to Danaya. So should anybody like those, then they can request a copy from her, and we'll also ensure that she has her email addresses. So if you have any further questions or if you'd like to talk, then please feel free to get in touch with us both. But other than that, thank you so much to all of you, and again in particular to Claudia for her support. And it's been an absolute pleasure. Enjoy the rest of your evening.